A man sits in a detention centre. He has a final order of removal. Every appeal is closed. The officers tell him the same thing his last attorney told him. There's nothing more we can do. But that wasn't true. One door was still open. Not the immigration court he'd already lost in, the federal court. And the key to that door was a writ of habeas corpus. So here's the question almost nobody stops to ask. Is habeas corpus your last option or your best one? Most people treat habeas corpus like a long shot, the move you make only after everything else has failed. That framing is everywhere, and it's dangerous. Because when you believe something is a last resort, you wait. You file every other appeal and motion first, assuming habeas comes after you've run out of options. But that gets the timeline backward. In a lot of cases, the detention itself is the exact legal problem habeas was built to solve. And here's the part that makes the last resort label so costly. A habeas petition challenges your detention, not your removal order. It runs on a completely separate track. So waiting on your appeals doesn't make your detention claim stronger. It just adds weeks or months of custody that may never have needed to happen. A writ of habeas corpus asks a federal judge one direct question. Is this person being held lawfully? That's it. It is not an appeal of your immigration case. It's a separate challenge, in a different court, to the legality of the detention itself. And that distinction is built into the law. The Real ID Act took away federal district courts' power to review final orders of removal. Those challenges go to the circuit courts through a petition for review. But habeas, under Section 2241, was deliberately preserved for one purpose: constitutional and statutory claims about the detention. So habeas isn't a fallback for a weak case. It's the correct tool for a specific kind of problem. And there are 3 situations where it's often the first, best move. Unlawful or prolonged detention. There are real limits on how long the government can hold someone. After a removal order, the Supreme Court's decision in Zadvidas v. Davis made clear that detention can't be indefinite. Once there's no significant likelihood of removal in the reasonably foreseeable future, continued detention loses its justification. And in mandatory detention cases, prolonged custody without a bond hearing can itself become the violation. When detention drags past those limits, that's not something you appeal. It's something you take to a federal judge directly. Due process violations. Held without a meaningful bond hearing, denied access to a lawyer, kept in custody through a process that skipped steps the Constitution requires. Habeas puts those violations in front of a court that has the power to act on them. Jurisdictional errors. Sometimes the government is holding someone under an authority it simply does not have. Those errors don't fix themselves. Habeas forces the question. So understand the difference plainly. Last option means you've lost everything else and this is all that's left. Best option means the actual legal problem is the detention, and habeas is the most direct, most powerful way to challenge it. Often it isn't the move you make after the strategy fails. It is the strategy. Every case turns on its own facts, and no outcome is ever guaranteed. But the costliest mistake we see is someone who had a strong habeas claim from day one, treated it as a last resort, and only filed after the clock had already cost them. Let me show you what that difference looks like in practice. 2 situations, same kind of problem, very different timing. In the first, a person was being held months after a removal order, with no realistic prospect of removal. Instead of waiting, a habeas petition went to federal court promptly, putting the lawfulness of that detention in front of a judge while the facts were fresh and the argument was at its strongest. In the second, a person in a nearly identical situation believed habeas was a last resort. So they waited, filed more motions, exhausted everything else first. By the time the petition went in, they'd spent additional months in detention. The claim might have addressed far earlier, and the picture had shifted in ways that made the path harder. And one thing worth being honest about, even when a court grants the writ, relief is rarely instant. A grant might mean release, or release under an order of supervision, or an order forcing the individualized bond hearing you were wrongly denied. The government can also appeal and ask to keep someone held while that plays out. That's exactly why timing matters so much. The earlier the claim is in front of a judge, the more room there is to deal with whatever comes next. Same tool, same legal problem. The variable that moved was timing.
So here's who should talk to us today. If you are currently detained or being held longer than feels right, don't assume the clock is on your side. If you have a final order of removal and were told there's nothing left to do, that may not be the whole story. A federal court is a different door than the one you've been knocking on. And if you're a family member researching this on someone else's behalf, you are exactly the right person to make this call. Contact Jeelani Law Firm today for a review of your specific situation. We'll tell you honestly whether habeas corpus is the right move, and just as importantly, when.